Good afternoon, ladies and gentlemen, members of East African Law Society and visitors who have joined us today for our webinar. We thank you for coming to learn from our able panelists today. Before I start, I would like to welcome our president, East African Law Society president, to usher in this session.
Thank you so much, Maura. A good welcome to all our members of the East Africa Law Society, my Lords Honorable Justice James Alala Deng, Justice of the Supreme Court of South Sudan, Honorable Justice Geoffrey Kiriawire, Judge Appellant Division, East African Court of Justice, Honorable Justice Retired Robert Makaramba, former Judge of the High Court of Tanzania, Honorable Justice Musa Sekana, Judge of the High Court of Uganda, Honorable Justice Alfred Mabea, Judge of the High Court of Kenya, and Mr. Jean Bosco Mutangana, former Prosecutor General, Republic of Rwanda. A welcome to you, my lords. We are excited to host you this afternoon for a sharing session with our young lawyers. My lords, the East Africa Law Society is composed of about 70% young lawyers. So the membership has more young lawyers than senior lawyers. So my lords, this afternoon is an opportunity for you to speak to our young members of the East African Law Society. And I want to take this special opportunity on behalf of the East Africa Law Society, and indeed on my own behalf, to thank you. Thank you so much for first allowing and accepting our invitation and allowing to share your experience with us. I look forward to this conversation, and I'll also be here listening in. Thank you so much. Thank you again. I'll hand over back to the young lawyers. Mine was just to welcome you. Maura, over to you. Thank you, Maura.
Thank you so much, Mr. President, for that warm welcome to our panelists today. We have judges with us. We are glad that you decided to take this opportunity and mentor the young lawyers. This is one of the many webinars that we are having as the Young Lawyers Committee called Mentorship Series. And we thank you for accepting to give us your expectation as judicial officers for the young lawyers. With me, I have my co-host, Rachel Musinguzi, who will proceed to introduce my lords and start our webinar after that. Rachel.
Good afternoon, everybody. You're welcome to the East African Young Lawyers Committee webinar. I'm here to introduce the different lordships that we have that will be presenting to us today. We have Honorable Justice James Alala Deng, who will be our keynote speaker. Justice of the Supreme Court in South Sudan, the Honorable Justice Geoffrey Kiriawire, who is the Justice at the East African Court of Justice. We have the Honorable Justice Retired Robert Makaramba, who is a former judge of the High Court of Tanzania. We have the Honorable Justice Musa Sekana, who is a judge of the High Court of Uganda. We have the Honorable Justice Alfred Mabea, who is a judge of the High Court of Kenya. And we have Mr. Jean Bosco Mutangana, who is the former Prosecutor General of the Republic of Rwanda. Maura.
Thank you. Myself, I'm Maura Nyakundi. I'll be your host for this webinar. I am an advocate of the High Court of Kenya, a member of the LSK Young Lawyers Committee, together with East African Young Lawyers Committee. I head the Communication and Technology Department subcommittee in that committee. I'm also a mediator and a founder of an organization called Metamalke in Africa. So as we're going to start, we'll start with keynote speaker. Mr. Justice Alala. Justice Alala, as you've all heard, he's the Supreme Court judge of South Sudan. I don't know if he's with us today. Thank you, thank you. So he's delayed a few minutes. We'll start with Dr. Justice Geoffrey Kriabure. Welcome. Please.
Thank you.
You're welcome, and we thank you for taking this opportunity to be with us.
I don't really have a very stable network right now because I had expected to be speaking towards 3 o'clock. I don't know if someone has a more stable one. In the next probably 15 minutes, I'll be able to make a presentation if you could accommodate me.
That is fine. That is fine, my lord. Mr. Justice Robert Makaramba, thank you for being with us again. So we are told that every judicial officer sets a standard on how, how his court should run. So we are here to learn that what advice do you give young lawyers on handling the different expectations from the judicial officers? My lord, Justice Makaramba.
Thank you. I think hello.
Yes, yes.
My lord, we can hear you.
We can hear you.
You can hear me, right? Yeah.
Yes, my lord, we can hear you.
I sent over the screen for sharing, and there's a screen for sharing, which is my presentation. Yeah, that is it. Please. Yeah, that's it. Yeah, I was usually set for their courts and what the expectations of the young lawyers, which means they have to abide by these standards. Now, my presentation has 4 parts. The first one will be generally an introduction and general overview. And I suppose I shall be playing the devil's advocate. I shall explain shortly what it means by devil's advocate. Then I'll go through the perceptions of justice on the life in court, and I've that order and science with judges and how to manage stressful business. The third part, I'll talk brief standards expected of the young lawyers, and this concept of know you're a judge has nothing to do with corruption, but you have to know that as well as observing and Decorum. First part, playing the devil's advocate. This is a long story cut short, but it means I'm giving out issues which will elicit some disagreement with others, and then you can have interesting discussion about the same Lord Diplo. I knew I playing the devil's advocate. Lord Diplock noted that the fundamental human rights is not to a legal system that is infallible, but one that is fair. So a justice system is about fairness. And what does fairness mean? Can you go to the slide with the lady with the sword? I don't know who is running the slides. Now, there is a public perception of justice, and this is depicted by the Themis, the goddess of justice. And essentially, it involves a blindfolded lady, which means that justice is impartial. And also, the lady is holding a pair of scales, which means weighing the strength of the claims, it's rare. And most of the present claims, so that way evidence symbolizes the power to enforce it. Because if you cannot enforce, that will be like a paper tag. Can be summarized by the words of Lord Henry years almost. And he stated the famous aphorism, "Judge should not only honestly and undoubtedly be seen to be done." And I think most lawyers know about this adage, which has been in the circles. This aphorism imposes possible office holders and equally the court office, because the lawyers are court office. A court holds a reputation, and the quality of judges also count. So what a judge is expected is to keep cool under the most extreme conditions. Now, a judge can keep cool depending on the players in the court, which involve the lawyers. Now, what does keeping cool mean? Is that the Lord Denning gave a very story about when he was sitting a lady who lost a case through he was congratulating them for their coolness under fire. Now, most judges, when they sit, and the young should know, they are also being judged by the clients, and one of them is the litigant and the advocate representing the judge. Now, what does keeping cool and fire means to a judge? Now, if a judge under a stressful environment, and also is for more kind of action. Now, etiquette. Now, judges are very training to do etiquette. However, the are required to keep the conduct of the advocates above both. It is to make this possible, and it is the judge who makes not the advocates through the diaries to receive orders from the judge, not the other way around. But we have seen when sitting on the bench, manage the courtroom by going by their diaries, especially when the dates are set for appearing. Now there are excuses, and a tough judge will not condone an advocate who is trying to control the room. The other thing is, young lawyers should know that practicing law is a noble profession. It's a calling which encompasses professionalism. Now, the pursuit of the highest ideals and the tenets of the legal profession demands certain qualifications. Now, those there are four most important essential ingredients of a professional. One is character. Your character matters a lot as an advocate. The other one is competence. You have to be very competent when you're appearing before a judge. And the other thing is commitment, your duty towards the court and yourself. And finally, maintaining civility. This is crucially in court, because if you don't maintain civility, actually you can anger the judge. Now, if that being the case, what it means now to know your judge, because once I'm in the court and I'm presiding over your case, I'm your judge, so to speak. So the standards I said, although there are standards set by the court, there are also standards by judges themselves. The first one you should observe is to stick to the court timings, because court not there, he might dismiss it. Of course, there are what we call overriding objectives nowadays and rendering justice, but you should know that sticking to the court timings is of utmost importance, which is to have a court for cases so that you can be prepared to proceed. The second one is information, because systematic handling is important to understand what's being said by the judge and also to be understood by the judge. So don't confuse your judge by engaging into some kind of tactics which actually will not benefit any of you. The other one is the space of appear in the court, because you have to make yourself heard so that the judge can know what you are saying. The other aspect should be timely, and as I say, we are well in court, so that when the proceedings, the timing of events will be monopolized by the judge. The judge will not wait for advocates' time, they will manage by their own time by the court. And any court within our region has a specific list within which to present your case. Now, knowing your judge, there is something which you as a lawyer, it is what a court of law, most of them say, is an area where both social values and the devices employed between them is a theater, but things which we studied that was no one can pretend that happens. For observing sometimes decorum. Now that it means getting prepared. Use the course list. Every court issues lists, and you have to know the time, the courtroom or the chambers, and the presiding judge for your client's case, because it will be very disturbing to court. You miss the chambers, you can also miss the case.
My lord,
that the courtrooms are important. Can you hear me?
Yes, my lord, your internet is shaky.
Hello?
You switch off your video so that the internet can stabilize.
Hello?
Yes, my lord, we are saying the internet is shaky.
So, okay, I've done it.
Maybe we will stabilize your internet.
Is it stable now?
Yes, we can hear you better.
Is it? Okay. Now, I was talking about observing court protocol or decorum, and essentially it involves getting prepared when you go to court. Now, because the preparation starts with knowing the cause list. So you have to know the time your case is being called, the chamber, and the judge who is going to preside over your case. Because if you don't do that and miss the chambers, you can actually miss the case. But what you should observe also is to keep to observe the rules of silence in the court. And this means nowadays you have electronic devices, make sure that you switch them off before you enter the courtroom. The other thing is I have seen when I was sitting in the commercial court, advocates, some of them coming holding bottled waters and everything, and they started drinking without asking permission from the judge. You shouldn't do that. Even the judge cannot have his drink in court. You make sure that you leave anything outside the courtroom, though you enter the court with only your case filed and nothing else. The other thing you should observe in the court, because the judges wear robes and the advocates are supposed to be dressed properly by observing formal court attire and avoid fancy clothing or styles and the glittery colors. There was some incidents I think in Jamaica where an advocate wearing a Rastafarian appeared in court and then irritated the judges. So this was actually a human rights issue, but actually you have to observe what the judge is saying, that if the court has given directions on the court attire and the formal way of appearing, then don't irritate the judges. I know in some jurisdictions there is this issue about whether an advocate should wear an hijab or a client should wear an hijab when appearing in court, but those are human rights issues, but every court has directions on how and how we should dress. So you have to observe what the court likes and what the judges are directing. Now, the other thing in the court protocol is the issue of bowing before the judge. Now, most young lawyers have this tendency of even bowing to the judge, even if we find him in a bar drinking his alcohol. Now, bowing before a judge means to the authority in court, not everywhere, even in the road transport. So when you are bowing before the judge, you're observing the protocol. I shall tell you, young lawyers, some judges can be really irritated if you don't bow when you are there before them. So this is not a small matter. It depends on the individual judge. But the other thing which can irritate a judge, and of course, there are no rules which are set, but is how you address your judge in court. Of course, in a number of our jurisdictions, there are different formal addresses of how you should address your judge. For example, in my country, you have to address your judge as your lordship or madam judge, and in the magistrates, your honor, your worship. And I think all of the jurisdiction, you find some formal. So know how to address your judge so that you don't irritate him for small matters. But the other thing is that most lawyers, when you appear in court, is to observe seniority and order of precedence. You know, the Attorney General is advocate number one, not by age, because of his statutory. So I have seen young lawyers appearing in court with senior lawyers, and the young lawyers start talking before their seniors have introduced them. So you should wait until the senior has introduced you so that you can start talking. Now, remember also to introduce individuals who are present in their respective roles, because judges get irritated if they do not know why are certain people in court and what is their role. In observing court protocol further, you should know how to manage your case file and records and your diary. I've had one instance where an advocate had the names of asking me to show him his file. Actually, he was supposed to come with his file in court. So, of course, some judges can actually be irritated. So, manage his file and record and where is your diary. So, and I urge young lawyers to learn to use the magical word, which is much obliged. This is magical. If you fail, you have to say much obliged. You don't show fairness to the judge, even if you have lost your case. Now, before judges and telling them, now I have lost the case, I'm going to appeal. Of course, appealing is your right. Why do we have to tell the judge? Actually, that's in terms of making submissions, this is very important. Make sure you keep your submissions very short and simple and to the point, because judges do not like verbose and a lot of Latin words, and most lawyers use winding statements without making any point. So, and if for any reason you lose your case, don't take it personal. You're supposed to be emphatic, not sympathetic to your client. You have a duty to your client, but you're not supposed to be sympathetic and start showing faces on the judge because you have lost your case. Losing or winning, that is justice, so long as it is fairness. Now, the other thing you should know is to mind your body language. Watch your client's demeanor as well as your demeanor. Your body language counts a lot when you appear before a judge. And remember that the courtroom is designed to be reflective of the triviality of the parties and advocates. And that's why judges sit at an elevated side on the road. Finally, to conclude, you as young lawyers, ultimately, you are officers of the court. You are supposed to assist the court to come to a fair justice and actually to comply with the 5 performance standards for any court, which are: 1, access to justice; secondly, expedition and timeliness; thirdly, equality, fairness, and integrity; fourthly, independence and accountability; and finally, public trust and confidence. So as young lawyers, if you do your duty as an officer of the court, you can assist the judge and his court to arrive at justice, and we can see that justice will really be rendered. Thank you for your attention. Thank you so much for your attention.
Thank you, my lord. Yes, we can hear you, and thank you so much for that presentation. The funny part about the Jamaican Rastafarian, it happens, and I think we need more guidelines on the colors, because with time we are wearing maroon and green to court. I do not know how bad that is, but I think with time we need to change our each country, the Law Society Act maybe, but we'll get there. Honorable Justice Geoffrey Kirabire, I think you're now settled. Thank you again for being with us.
Thank you, Maura.
Yes.
I am able to make a presentation. Just confirm that you can hear me properly now.
Yes, we can hear you. From what my Lord Makaramba said, that we have a lot on character and competence. We have to maintain our duty as young lawyers and lawyers in general. My question to you will be, I'd like you to share what court decorum practices do you feel lawyers take for granted or disregard that are key and expected of any lawyer?
Thank you for having me on this webinar. It's always a great pleasure to share with young lawyers. We too are young lawyers at one point, and we were able to benefit from mentorship. So I congratulate the East African Law Society for being able to put this webinar together. It's also good to see my old friends, Justice Sekana, Justice Makaramba, and others also being part of this webinar. I think when you're talking about the expectations of decorum in court, we need to understand what we're talking about when we say decorum. Really, we're talking about maintaining the dignity of the court. And people must know that those who come to court come to seek justice, as Justice Makaramba has said. And justice means that there is a sense of expectation. If you're going to get justice in a place which is very disorganized, very does not give you confidence, then you may find that you will go and use other means like self-help, which is not good. But I'd like to raise about 4 or so points. Some have been already ably spoken to by Justice Makaramba. But the first thing I need to emphasize is this. There's a tendency for people to say, there's a tendency for people to say that if you are retained by your client, then your first duty is to the client. And this is one of the things that causes conflicts in the courtroom, because the way we set it up, at least in the common law system to which Uganda, Kenya, and Tanzania are part of, the advocate, his first duty is to the court. So in presenting his or her case for their client, they need to assist the court to come to a just decision, and not to simply win their client's case at any cost. It is this that causes problems of what is expecting the advocate to cooperate with the court, and the advocate has instructions not to cooperate with the court. And this therefore leads to a breakdown in decorum at the court. So we need to be clear about this. Even though you are by a client and you're well paid by that client, you must remember at all times that your primary duty is to the court. And the signpost that you are supposed to look to is that of truth and justice, so that the court can arrive at a just decision. So sometimes it is quite clear that the conflicts will arise, for example, where the advocate will come and not tell the court the truth. We have had examples where advocates have come and say that my client is out of the country, and therefore we seek an adjournment. And as you are leaving the courtroom that day, you find that the client is walking past you, but the advocate was able to give a plausible excuse for the court proceeding not to go ahead. Now, this is certainly not the best way to allow for the dignity of the court. The other one, the second point which I'd like to highlight, and I'm bringing it as simply as I can, because sometimes we play about with these phrases and we do not understand what they mean. Under the common law system, members of the bar are regarded as and refer to each other as learned friends. In other words, you are in a friendly relationship with counsel opposite. And therefore, in presenting your case to the court, you want to present it as clearly, as calmly, and as correctly as you possibly can. But sometimes what we see in the courtroom is a battlefield between lawyers, a raising of voices, accusations and counter-accusations, which brings into contradiction even the language that's used. So you find a lawyer saying, my lord, my learned friend is being deceptive or is a liar. And you have back and forth trading of accusations and bad language, which destroys the decorum of the court. And so we must understand that if we are to call counsel opposite your learned friend, then certainly the manner in which you present your case before the court should reflect that statement. Otherwise, probably it may be more correct to say that you are learned enemies. And this needs to be explained to the clients, because very often when the cases are over, and of course, having been an advocate myself, and I know this as a fact, some of our clients get confused because when lawyers leave the courtroom after presenting their cases in an adversarial manner, they are seen talking to each other and also perhaps even suggesting that they should go and play golf the next weekend. And the client feels that that sort of relationship will compromise the case. It should not, because the profession is designed around the lawyer maintaining friendship with counsel opposite, even in a situation of an adversary litigation. And this is very, very cardinal to the way we practice law, because it allows the court to maintain the correct dignity that it should have during the hearings. So collegiality is expected amongst lawyers in the courtroom. So you do not take counsel opposite as your immediate enemy. And therefore, when you are to agree, for example, on a process in the court, then this should be done with a collegial approach. The understanding for some lawyers who are not well grounded in the profession is that whatever concession is required of them, they must oppose. So it makes the proceedings a lot harder, especially if the concession is for the benefit of the court. Today, for example, we are living in a period of a pandemic. We are living in a period where there are certain social operating procedures, or SOPs as they are known in Uganda, where it is not possible to be together all the time. And so one party may say, in order to progress this case, let us file written submissions. The other party will say, no, I want to be in court physically, and therefore make it very difficult for the proceedings to go ahead. This lack of collegiality is a very big cause of lack of decorum in the courtroom. And sometimes the judge is forced to ask lawyers to come to chambers and try and understand from them what is the big thing about the concession, if it is to progress the case. So that is the second point which I really thought we need to talk about. The other third point which I'd like to highlight is one of preparation. If you are given a brief to go to court, then you need to prepare. Sometimes we are very popular lawyers and we take on more work than we are able to manage. We book time in various courts at the same time. And therefore, there is a sense that the court proceedings should be hurried to accommodate you to be in another court running at approximately the same time. Now, this always creates an environment of conflict in the courtroom and is very, very problematic. So there are examples, and I believe you may know them, where there are certain lawyers who then get branded within the courts. And I can say this with confidence in my judicial practice, that I know in certain law firms, if a particular lawyer is to appear, even before he or she addresses the court, I know that that lawyer is going to make an application for an adjournment. And yet they're the same people who fixed the case for hearing on that day. They become what I have coined adjournment specialists. They never argue cases. They come to adjourn. Now, when you take out a hearing date in our congested courts, you are denying somebody else access to the judge or to the judicial officer. And so if it is your desire to fix a case and the court gives you a hearing notice, you need to prepare for it. And sometimes the court becomes tough and says, this time round, we will insist that you proceed. And then counsel will say, in that circumstances, my lord, I pray to withdraw from conduct. And you find that the bar and the bench are in conflict. This is normally a disease of preparation. Lawyers by now in practice must know the 3P principles for a good lawyer. The first P is preparation. The second P is preparation. And the third P is preparation. If you are not prepared to go to court, then you should give up that particular date and allow others to take it. Because if the court has blocked its entire day to hear your case, and then you say that you are unable to present your case, it means that the judge cannot call on somebody else to come and take that time. It is not a good use of judicial time. So once again, allow me to say that when you are in court, you need to be prepared to proceed. It used to be my practice as a high court judge that even where counsel took out a date on a particular day for a hearing, and he got a hearing notice from a superior court, for example, the Supreme Court, that I would still proceed because it is for the counsel to manage his diary. It is not for the court to manage his diary for him. So if you want to be like the Holy Spirit in more than one place at the same time, then you need to be like that. But if you take out time in my court, it is very important that you show up. If you're unable to show up, then you give brief to another lawyer to show up because I have taken out that particular time for you, for the benefit of your client. So that is my third point. My fourth point, and I think Justice Makaramba has also pointed to it, that my last 2 points are amplification of what he has said, is the issue of timekeeping. And this is even more important nowadays when we are operating courts virtually, because you're also taking up virtual time. And it is important to be in court at the right time and in the right place, in the right courtroom. It is a matter of absolute respect for the court, for you to be there when the court expects you to be there. As a law student, I remember being taught very clearly that counsel wait upon the court does not wait upon counsel. That is for good reason, because we want to maintain the decorum of the court. So if you show up late and in a half, and your books are not with you, your robes are not with you, you are in an absolute state in front of the entire court, then certainly this does not augur well for the dignity of the court. So it is therefore important that time is observed. And when I talk about time, I do not talk about presence only. I am also talking about being on time in filing pleadings, in filing affidavits, in filing submissions, whatever the court may have asked you to do. This is critical, because proceeding in the default of presence or in default of pleadings is always a nuisance, because counsel will then try to come back and ask for expansion of time. Finally, let me talk about professional dress and amplify what Justice Makaramba has said. In the East African Court of Justice, we allow you to dress in your official court dress in the country of your origin. But we must remember at all times that the law profession is a professional, it's a profession, and the profession is guided by traditions. When I see a lawyer appearing in professional dress, then I also understand that he knows why he's putting on that professional dress. I do not have sufficient time to go through all of this, because I see my time is almost up. But if you're out of the common law profession, you will know why you wear a black robe. You will know why the black robe has various components attached to it. You will know why you wear flaps. You will know why, if you are wearing a wig, you wear it. Yes, they say this is out of colonial mentality, but even if you accept that, there is reason for each and every the way that the robe is structured. And it is to remind the lawyer that he is in court to ensure that justice is done, and that justice is paramount over everything else, including his own professional fees. I thank you for listening to me.
Thank you very much, the Honorable Justice Geoffrey Chiawire. I hope everybody can hear me. We did not get a chance to introduce the Honorable Justice Chiabire before he started, but this is just his brief profile. He's a justice at the East African Court of Justice, and prior to that, he served at the Court of Appeal of Uganda, and before that, he was the head of the. Thank you so much, Honorable Justice Geoffrey Chiabire, especially for telling us about preparation. As young lawyers, this is the kind of advice we need. This is the kind of briefing we need, because we just get into the field when we don't even know how to carry ourselves in court. At this juncture, I'd like to recognize the presence of Honorable Justice Musa Sekana, who will be our next presenter. He's a justice at the High Court of Uganda, where he serves as the head of the Civil Division. Over to you, Maura.
Thank you so much, Rachel. We have Justice Sekana came in late, but thank you for making time to be with us here as young lawyers. We have learned from the two previous panelists and speakers that we need to have decorum in court. That is basically what we need to do during the sessions. Now we have finished with the court session. We are coming to our pleadings. I would like you to engage us on what are the most common mistakes made by lawyers while drafting court pleadings, and what tips can you give us to do better pleadings and submissions? My lord, thank you.
Thank you very much, Madam Moderator, host, Yomura. Thank the organizers and the host for making me part of the panel. I thank the previous speakers, the retired Justice Makaramba and my senior brother, Justice Chiabire, for what they have expounded to the young lawyers. Court pleadings and what the young lawyers ought to do is really very important. A case is won from pleadings. Now, if your pleadings are floppy, you're definitely going to lose your case in court. This is the first document a judge is going to be exposed to know about your case. What is it that you are putting before this court? It will show the organization, and this will now set the expectation of the judicial officer. If the pleadings are bad, the judge already takes or forms an opinion. Judges are human beings, you are all aware. Now, if I find that the English is poor, the language is bad, expression is incoherent, straight away I'll wait to see the lawyer who drafted and when he appears in court. Now, what I've realized from the period I've been at the bench, lawyers receive instructions today at 4, and tomorrow by midday, the pleadings have been filed and they are in court. That is extremely wrong, extremely wrong. Where I had my training as a young lawyer, we would discuss a plaint with my senior for over 3 months, editing, correcting the English, the mistakes, and reading authorities. By the time we file a plaint in court, the suit is as good as won. We have the authorities on file. We have all the things that we needed. And once the case is pleaded well, it makes it easier for the judge to comprehend whatever you want to say. But the cases I see in court, some incident has happened on the streets of Kampala. They have beaten rioters. A young lawyer is filing an application in court tomorrow. Now we begin waiting for several of them to file so that we can consolidate them. But when you read how he has pleaded, you can't believe. And as a judicial officer, I expect excellency. Unfortunately, some of us had a background of being lecturers at universities or higher institutions. Now, I expect excellence at whatever level. I will not reduce the standard even when I'm a judge. Now, the excellence will come through preparation, as Justice Kirabwira has stated. The preparation is the pleading. What are you pleading before this court? What are you presenting before this court? What is the case that you are really pleading? It will guide on the witnesses you will need, what points you are going to, what facts are going to be agreed, what points will have to be proved by which type of evidence. Do you need experts and things like that? Now, that comes from preparation and appreciating the case your client gave you. But you can't interview a client today, then next week you are in court. Yes, we appreciate there is that sense of urgency, someone wants his case in court, but being thorough, being prepared is important. Now, whenever you are drafting pleadings, these are some of those basic things. I don't know whether you are taught at the law school, but at least those I taught, at least I remember telling them, whenever you are drafting pleadings, first identify the cause of action. Now, once you've identified the cause of action, then draft your pleadings according to that cause of action. What are the ingredients of that cause of action? What is expected? We all know the famous auto garage Motokov. The person enjoyed the right. The first paragraphs must set out how that right was enjoyed. Then the subsequent paragraphs must allude to how it was violated. Guided by Motokov case, how was it violated? The last paragraphs are talking about liability, how that party is liable. Once your plaint or your pleadings do not allude to those three elements, then your case is as good as bad, and it's just a question of time. And that's why when the defense files, straight away they will begin by saying we shall raise a preliminary objection that the plaintiff does not disclose the cause of action, because you have missed out on those three ingredients. But once the three ingredients are made out, it becomes easy. Yes, of course, you may not follow that order if you are the disorganized type, who is not prepared, who is not thorough, who doesn't look at excellence. A cause of action can mean any complaint in whatever form you can call it, a complaint against a party. Now, you throw around your whole narration as if you are a lay person, and you without even alluding to those principles of a cause of action. But when the court reads through, I can make out a complaint. I can see you have something against the other party. But remember, you are beginning your career and you want to begin it on a good note, on a high note. And the portrayal you will have before the judge when you drafted good pleadings, after I've carried my file home, read your file, then when I come back the following day, I'll wait to see this smart lawyer who presented to me a case well pleaded, and I'm just waiting for him to lead his evidence. The case is already made out, especially for the plaintiff, if assuming you're the plaintiff or applicant, as the case may be. Now, when it comes to a defendant, you must know how to plead your defense. How do you structure your defense? Now, you will find sometimes it's true, I wouldn't try to blame because I was in private practice also, where you receive instructions maybe 3 days or 1 day or 2 days to the time allowed to you by the summons that you must file your defense within 15 days. But again, being thorough must not be thrown through the window, because that defense, as you're all aware, you cannot lead evidence to prove what you did not plead. Now, your defense must actually be a defense. As you all know, in all our rules, I think in the East African region, provide for striking out pleadings which don't disclose a defense. at least in Uganda, Order 6 rule something. Now, if your defense doesn't even make out a defense, you shouldn't even appear in court. That's what it means, except that we have liberal judicial officers who have not gone that hard way. But the hard way I can be is, as soon as this is not true, this is denied, you'll be put to thereof, this is denied, this is not within my knowledge. Now, is that a defense? That can't be a defense. Someone says, we had a contract, you breached. Now, what is your answer in respect of that allegation of breach? Did you breach or you did not breach? You can't say this is not true. Okay, if it's not true, what is the truth? That's what the court is looking for. We are a court of justice. I'm looking at how to get to the truth of the matter. Now, I can only get to the truth when you give me a version upon which I would be able to evaluate to know between the two parties who has actually breached. Now, after making, I usually call them a one-page defense of this is not true, this is denied, strict proof thereof, and up to the end, one page. And it usually comes from Attorney General's chambers sometimes, where basically to me, they normally don't have a defense. But you who has received instructions from a client, you can't receive instructions to write the one-page defense. If you found a strict judge or judicial officer, he will strike out that defense, and that is the end of your client's case. And that's the biggest embarrassment you will ever get, that actually your case was dismissed. Your defense was struck out, therefore you couldn't appear to lead any evidence, and that has now affected your whole case. So preparation, as the judges have emphasized is key, and it goes ahead with receiving proper instructions so that you don't get into issues of amendment. Now, we have realized that there's a lot of requests for amendment of pleadings because of not being prepared when you're making the plaint in the first place, or the defense. Because if I was thorough and I prepared my plaint for over 2 months, I think an amendment can't arise. But because you received instructions today and you're going to court tomorrow, now when you discover new things, you realize that the case is so shallow. And if you have to proceed with it, you have no headway. The next thing, before the case is even fixed for hearing, an application to amend. That's when you realized you added the wrong party to the pleadings. That's when you realized you left out some reliefs the client wants. And indirectly, it's forcing you even before to have, you can have as many amendments to the pleadings as the number of times you've appeared in court. Whenever the judge talks about something, I read this and it was not clear. What did you mean here? You realize there's a gap. The next thing, an application to amend. Now, that means you were not prepared, or you came to court haphazardly, you lacked the confidence, or you did not interview your client thoroughly to guide you. You never presented your client's case the way it ought to have been presented. But a smart lawyer, a smart young lawyer must be prepared and must read. If the cause of action is breach of contract or negligence or whatever tort, you must have those principles upon which that cause of action arises, and ensure that all those facts are extracted through a thorough interview with the client. Otherwise, you cannot draft a plaint on a small email brief of two paragraphs, and then you want to run to court the following day because you're in competition, or if you delay, you want to get quick money from the client so that he pays you and you file so that he doesn't run to another lawyer. Now, that's when you do the shorter job, and the next thing, the client will never come back to you because he knows you should have told him, say, no, look, I've read the brief, but I think I need more information for me to be thorough in your case, for me to be able to present your case so well before the court. Now, if that has not happened, you are running the risk of this client never coming back to you, and also recommending others that you are not a stable lawyer. You don't know what to do, or because you didn't tell him, and the client will always feign ignorance. It's okay, you are the profession, I came to you. Why didn't you tell me that you needed more information? Why didn't you tell me that you need one more documents? Why didn't you tell me that we needed this? Now, at the end of the day, it becomes a blame game between you and the client. And by that time, you have lost that client. So Always be prepared through these pleadings, be thorough, and even when you are preparing, when you're reading these decisions of court, try to look for the latest decisions so that it guides your pleading. You may be relying on a precedent of your grandfather who was a lawyer. Now, that case of 1920, 1915, changed the circumstance. Whenever the cases are interpreted in court, they refine the law to the latest date. Now, when you're drafting a case of breach of contract, there are some principles which may not be applicable that could have been good principles in 1920 or 1940, but now with the changed circumstances, they have been overtaken. Now, you're able to plead, and the judge is able to comprehend from your pleadings that the case is going this way. That's what you are looking for. That's what you're striving for. If a judge does not understand your case from pleadings, don't think that you will line up 20 witnesses for him to understand. He will just even be more confused, and he will never comprehend. He will just try to find a way of how to get rid of the case, because the pleadings were so bad that because indirectly you are likely to change your case from how you pleaded it. You left out very many things. Now, parties are bound by their pleadings. You are leading evidence on something not pleaded. As you're leading your evidence, I look at the plaintiff, I note. Some judges interject at that stage, others don't, because currently we have witness statements. You may try to smuggle in all those things which you are well aware were never pleaded. Now, once the pleadings are bad, the case is as good as lost at that stage. You need to be prepared and to be thorough when you're going to prepare pleadings. Take time off, read different authorities around the area so that you know you have tied your case in all angles, and you leave it to the defense to find a way. And indirectly, sometimes when the pleadings are so thorough, the other party is forced to concede, because he will take it to every lawyer and say, now, it seems this case is watertight. I don't see us getting any headway. But what we do, let's just find a defense as we try to negotiate, or we find a way of settling the matter, which works for you. And that will have come from the good preparation you had on having good pleadings, which you presented in court. I thank you.
Thank you very much, the Honorable Justice Musa Sekana. Thank you for your presentation. Somebody raised the question. He says, I have a question to Honorable Justice Musa Sekana. How are we to deal with a client who comes with instructions under certificate of urgency? My Lord, if you can answer that one before we proceed, please.
You see, usually when a client, because you need to establish really, okay, where has this client been? That's the starting point. Because you can't come to me and say, now, yes, I know we are now in court vacation. You are coming on a Wednesday, you want the matter in court. Why is the urgency, first of all? Now, if you're willing to take on a matter of that nature, which is urgent, now you will have to borrow more time. You'll have to forego part of your sleep. You'll have to take off a night to be thorough. Even under the circumstances under which you're operating, you really came to court, you prepared. It's not reason enough to say the client brought instructions very late, they were under a certificate of urgency, and because don't throw your name, don't lose your name or your good name because of this one case. Otherwise, the image out there will be, it will haunt you for the rest of your time. It was okay. The last time this fellow appeared very disorganized, he didn't know what to do, his pleadings were shabby, he amended several times. Now, assess whether you're really ready to take on this case, which is urgent. If you have to, then suspend all other things you're supposed to do, take off some nights to do a thorough job. But I know lawyers say, no, I don't carry work home, I don't do what, but whether you carry it home or not, it's still your work. You'll have to do it. So you've taken on the instructions, you've received the good instruction fees, you went laughing to the bank, the fellow left you 10 million, now work for it. be thorough, so that he also appreciates that actually in the shortest time I gave this fellow, he did a thorough job in the circumstances based on the information which I had, as opposed to now just taking it and then you begin giving an excuse that you see, I would have done a good job, but you brought the instructions very late. Why did you take them? You would have rejected, or you would have found alternative ways. But once you've accepted, take on the elephant, carry your cross up to the end. But you will not compromise excellence and quality for thinking that because the time given to you was too short. Thank you.
Thank you so much, my lord. That was a very informative session where you've told the defense lawyers, I think we are now ready to do a thorough job. We have been hit hard with our one-pager defenses. Thank you so much for that. From our pleadings, we'll go to court and then we'll meet submissions. This will be presented by Honorable Justice Mabea. He's a High Court judge in Kenya, the presiding judge of the Commercial Division. My Lord Mabea.
Thank you, Mora. Thank you, our host. Thank you so much, those my colleagues who have gone ahead of me, and for their beautiful and very enlightening presentations. Yes, I will take it up from where my colleague who has just completed his presentation, from where he has left. Mine is on the submissions. After the case has been, either the case has already been concluded through trial, or it's a submission on an application. There are several assumptions that you must make as an advocate. These are, you must understand, as my colleague has said, judges are human beings with the feelings. They can get tired, they can be impressed, they can be disgusted, and all that. Secondly, you have also to make assumption that the judges in this, in the third world, you have a lot of work. It is not only your case which they are dealing with. You've seen the course lists, which the daily course lists which they deal with, and the many decisions that they have to write as a result of the cases that come before them. Therefore, it is not only your case that they are dealing with. The other assumption is that you must assume that the judge has read the pleadings or the depositions in the record, and he has also heard the witnesses, and he has therefore understood your case. This may not be a general principle, but this is a general rule for those judicial officers who don't read the files when either you are coming to make submissions. That is the exception. But the general rule is that please understand that the judge has read the file, he has understood the matters that are in conflict, and therefore you may not need to rehearse. Unless it's a judge who has come while the case has already been concluded, and under the rules, he has to write a judgment, which was a case was done by his predecessor. Finally, the judge presumes that you have understood your case as well as your opponent's case thoroughly. If it is at the judgment level, I know that you must have read the pleadings. If there are other depositions which were given during the interlocutory stage, those which relate to the trial, whether there were admissions that were made, those are issues which I will expect, or the judge will expect that you know. And for you, understand the judge. The first presenter told you to understand the judge, to know the judge. All the judges are not the same. There are those who will not mind you going through the entire story of history of the case, and there are those who are very precise. So it is very important for you to understand your judicial officer. How do you understand your case and your opponent's case? That is what the immediate presenter has told you. That the famous FILAC principles. You know and you have understood all the facts. You have known all the issues that arise. You have known the law which is applicable. And you also know how to apply that law to your case, the case which is before court. Once you have all these assumptions, then what do you do with the submissions? The first point is that your submissions must be very concise. It is not every issue that arose during the trial that is important in the determination of the matter before court. You should use proper, simple language and avoid legalistic language. Don't make the judge, who probably will be writing the judgment at the confines of his study, to try and refer to the Saurus and all the other legal dictionaries to be able to understand and comprehend what you are communicating. Use simple language. All that is required is you communicate your client's case and make the judicial officer understand. Therefore, avoid being verbose. Lengthy submissions sometimes are tiring and disinteresting to the judge. That is why I say you must make the assumption and know that the judge has many other decisions to write apart from yours. Therefore, there is no need of you having to write 15 pages of submissions. Submissions which are very concise, 3 pages or maximum 5 pages, provided they take all that is required, they are enough. There are judicial officers or judges who will restrict and tell you, 1, write 3 pages, or submissions should not exceed 5 pages, double spacing, font 15 or font 14, font 16. Why do they do this? I have seen submissions which the lawyers use very small prints, single lines, because they want to save on paper and ink. Yet they fail to know that probably most of the judges are old fogies, and their sights they're losing sight, and therefore they will strain a lot to try and read your submissions. Please let your if they are written submissions, let them be attractive so that they are inviting, they are impressive, and they make the judge to read the entire submissions. This also applies to oral submissions in the courtroom. You must be very precise, go to the point, don't go all around the case. Number 2, use of authorities, both written as well as oral. It is very important when you back the law, you back your case with, or your submissions with case law, or you cite the law, the relevant law. And when you cite the authorities, supply those authorities. If it is written submissions, ensure that you have supplied copies, and if necessary, and I emphasize this, if necessary, highlight the areas or the portions which you think is relevant and which the judge is you think will invite the judge's mind as well in making his decision. Do not mislead the court. We have seen advocates who quote in the written submissions, and they say in this case, blah, 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 blah. The judge held, it is a court of appeal decision, probably where there is split decision, instead of saying the dissenting judge said this, and this is now what I invite the court to apply. He cites it as the authority. Then when the judge goes to read and he finds that it is misleading, it is not the holding of the court, the judge takes offense of that. And as my predecessor said, being human, when you mislead me, as I go down the writing, the judgment or the decision, already I have a negative attitude on the person that I'm dealing with. And you know what that means. So in every step that I go down, I know what I'll be looking for instead of positivity. It is negativity. So get your authority as well, align them, highlight them, and they should be applicable. The third area, the third issue is submit only on the issues that were raised in the pleadings and the ones which were settled at the pretrial stage. Having said that you should not be verbose, I will not expect them, the lawyer is not expected to rehearse and restate the entire case of his client or the defense. All that is required, one sentence or two sentences. This is the plaintiff's case. The plaintiff's case is that this is a contract, lending by a bank. The plaintiff took a loan. Charges were executed. However, we are challenging the charge because of probably wrong execution. Then you proceed. You proceed with whatever the evidence that was given, not the entire evidence. One issue, what the case of the plaintiff is, the evidence that was submitted, what the defendant said, his defense, the evidence that was given. Then now you give the law. What is the position of the law on this issue? And how does it apply in my client's case? That is now the conclusion. That one now invites the court to see the conclusion where the decision of that issue goes to. So that one makes it easy for the judge to be able to understand your submissions. And when he's going down there, because he has already read the pleadings, he has read the witness statements, he has also read the cross-examination on record. And now all that you are doing, you are raising the salient features or areas which you are putting emphasis and which you are inviting the court to look at as the judge is writing his ruling or judgment. In this regard, therefore, you must be very, very careful at the pre-trial stage, at the case management level, to be able to frame the issues properly, to ensure that the issues were properly framed, so that when you come at the trial or when you are submitting on your application, your case comes out clearly for the court to understand. The fourth area which you have, which I will put emphasis on submissions, and these submissions both they apply both orally as well as in writing, is the structure of your submissions. Your submissions should be structured logically. There should be a flow. They should be very clear and easy to understand. When they are mumbo jumbled and the judge is not able to know where the beginning is, where the body is, and where the conclusion is, becomes very, very difficult for the judge. And as I said, the judge can be disgusted, the judge can be angry, the judge will not deliberately, but out of probably anger, fail to consider those submissions. And all that you will do is to complain that the judge did not consider my submissions or our submissions on record. In this regard, as young lawyers, you still have a lot of time. I always tell those who are still young in the profession, if you want to understand this, take as much time as possible to read decisions, judgments of courts, both in the superior courts, our Supreme Courts, Court of Appeals. You will see how those judgments are structured. You will see how the judges tell the story. You will see how they are able to communicate the case and the decision. That is how you are supposed to be with your submissions. You will see how inviting those judgments are, and you will see how clearly they communicate to you. That is how your submissions are supposed to be. The same way you read a judgment and you understand what the court is talking about, what the case was about, and it communicates to you the decision, the dispute and the decision. That is how you're supposed to tailor and present your submissions in a logical, sequential manner that makes sense. Judge knows where to begin, where the issues are begin, and how they have been argued, how they have been presented, and the conclusion. Therefore, you should format them in a uniform manner that makes it easy for the court to understand your client's case. Fifthly, in both, this was said earlier on by one of the presenters, ensure that your submissions are filed timely. If you are given 14 days, ensure that within those 14 days you have prepared your submissions and filed them. In this era of virtual hearing, there is a tendency, I will give an example of what I do. If I heard you today, I would say file your submissions within 14 days. The other side within 14 days, judgment will be in 60 days. Of course, I'll be looking at that decision on the 50th day, 7 days or 10 days before the date of delivery, so that I can prepare it, brush it up for delivery. If you do not have filed on time, of course, they will not be on record. It's not the last day. There are those the judges who write probably the decisions 14 days before the date of delivery, and they will not have the advantage of having seen your written submissions. The other on oral submissions, if you've been given the timelines within which you have to make your submissions, it's 15 minutes, it's 10 minutes, it's 30 minutes. Having thoroughly prepared the previous day, how you are going to present it, will make it possible for you to know which parts and portions of your submissions you don't need to present, so that you can be able to finish within the timelines given. I said that a judge is human. If I have given 3 lawyers 1 hour, it's 20 minutes for each. If you do not go within those timelines, of course, after that 1 hour, the other case is coming up. If you are presenting orally, after 15 minutes, you have not even dealt with your 3 issues out of the 5. You have dealt only with the 2 out of the 5. When the 20th minute comes, I'll be forced to stop you, because the other parties need also to make a presentation. So a judge can be angry if, when he has presented, he has stated it is 1 hour for the three of you. On the 20th minute, you had only dealt with 1 issue, and yet you say, I need another 5 or 10 minutes. Where are those 5-10 minutes coming? And that is where now, of course, the better part of the court, the judge, comes in. He may be, no, you are pulling the court so far, becomes angry, and it may become nasty. And that is what I mean when I say the judge is human. The judge is human and subject to all the feelings you can get angry, you can get impressed, you can get disgusted. I get impressed by when I see lawyers who are prepared, lawyers who know their case well, lawyers who present their case very well. If you did today that's a good presentation, tomorrow when I see your matter, in the morning when the judges look at the files, they look probably the previous day, and he looks at the course list, and he sees this is today the lawyer who is coming is that Katankaras lawyer. You destroy his mood in the morning. But there are those when he sees, oh, lawyer so-and-so is coming. That lawyer knows his case. He will present it in a manner which is so logical that you make it what? You make the judge what? Impressed. Thank you so much. That is all I had for you. Thank you. Good afternoon.
That is very, very insightful. And there's a concern, however, before we proceed, that Pius Katunzi is saying, my lordship, kindly clarify the issue of judges being human is still confusing. Can an advocate lose a plaintiff's case merely by being annoyed to the judge, even when he's right on the law, pleading? Will that be unethical for the judge to allow anger to influence his decision?
Thank you, whoever asked that question. Why should you be rude to the judge in the first place, counsel? The work of a counsel is to plead his client's case. You plead to the best of your ability. You must be in a position to put it in a manner, although forcibly, but not in a manner that is supposed to anger the judge. What I usually tell those who are the advocates that I meet in the bar bench, is that although I will not hold you against your client, tomorrow you will come for a certificate and I will say, I don't see any urgency here. Because you are rude, you don't have decorum, you all do that. When you need the judge's discretion, you will not get it. It is not that you will lose your case or your client will lose your case because you have angered the judge. But remember, when the time comes for exercise of discretion, that discretion will be denied of you. And probably it is in the most deserving time and the most deserving case that exercise of discretion will be used. Thank you.
I see many questions your way, but we will deal with them after the last presenter. Before then, we want to recognize the presence of Justice Funalis Okubo, the Registrar of East African Court of Justice. Thank you for being with us. We, as the young lawyers, really appreciate. Over to you, Rachel.
Thank you, Maura. I also recognize the presence of His Worship Funalis Okubo. It's a pleasure to have you amongst us here, amongst the young lawyers of East Africa. We have 250. I see some of you are raising hands, but I think if you have a question, instead of putting it in the chat section, kindly drop it in the Q&A. Then we shall deal with it after the next presenter. A question, and please don't just ask any question. The theme of this today is expectations of a judicial officer, expectations of judicial officers, of young lawyers. What these judicial officers expect from us in court. Yes? Yeah, because there are some questions I'm saying that are really not about this. So let's stick to the theme. Our next presenter is Mr. John Bosco Mutangana from the Republic of Rwanda. He's the former Prosecutor General of Rwanda, senior partner at Mutangana and Partners Law Offices in Kigali, Rwanda. And we are blessed to have you in our presence. The question you're going to handle, or the topic you're going to handle, is from the bar perspective, what advice would you give a young lawyer practicing criminal law, especially in light of this pandemic that has made, among other things, physical contact extremely risky and also it has complicated certain criminal law procedures. Over to you, sir.
Thank you very much, moderator, for the opportunity to speak to this Young Lawyers Mentorship Series under the ELS leadership. I'm pleased to be with you this afternoon and happy to have been invited, as well as inviting Rwanda Bar Association to this series. First of all, my presentation will be focusing on the impact of the COVID-19 vis-a-vis the practice of young lawyers and the kind of advice that we need to give them as senior lawyers. And I'll be talking about 4 key points in the discussion as the advice. The first one is the conduct of the lawyers themselves in the middle of the pandemic. Number 2, I'm going to talk about rethinking and investing in new ways of making justice systems more responsive and inclusive. Number 3, I'll talk about strategy of promoting institutional relations. And the last one is I'll talk about virtual court and remote sessions that we are undergoing these days as a way of solving the problems. So first of all, the impact of the crisis itself, as well as the legal and policy responses developed by countries to counter the spread of COVID-19 have much wider ramifications that affect a broad range of human rights in criminal proceedings, including people access to justice in a timely, fair, and effective manner. So I think this is what young lawyers have to understand. So the pandemic has not only affected the justice sector itself, it has globally affected all spheres. So understanding this itself allows us to proceed to understand what we have to do. Because the pandemic has put, among many other, the legal practitioners into uncertain times, especially when it comes to assisting clients with respect to those defense rights, very pertinent defense rights, such as access to defense of their choice and many other rights associated with a due process. So it has therefore affected lawyers with regard to their ethical responsibility to the clients, not only young lawyers, but generally speaking, lawyers in legal practice. For young lawyers especially, they wish to maintain their competence at an early stage of their career, of their practice, and the situation does not favor them in view of a career that they're eagerly willing to perform diligently when they start facing this kind of frustrations caused by the pandemic. Nevertheless, it should not hinder the zeal and the vigor of young lawyers willing to perform their duties in defense of their clients' rights. So however, what we have all observed, young and old, is that with physical contact extremely risky and complicating criminal law procedures, this has caused everyone to experience some kind of stress and some kind of concern, especially with the demands and the answers that we have to give before the courts of law and the clients that we represent. One of the key aspects, in my view, is lawyer-client communication. It's very fundamental at this stage, and it's very difficult at this stage of the pandemic. And young lawyers need to understand how to maneuver through this kind of challenging landscape, the legal landscape, as well as the pandemic demanding situation. So the lawyer-client communication, especially including prison visits, which is almost impossible nowadays with the pandemic. So they need to understand how this is going to impact their clients, and they need to understand as they develop their career that this is one of the most key important issues of an advocate, the communication between the client. So going to the first point, the first advice to young lawyers, the first tip is the conduct of lawyers themselves. First of all, they need to protect themselves against the pandemic first in view of their legal practice, and try to minimize risks of contracting the virus itself in view of the practice. Lawyers should have personal protective equipments And this is the first guideline that we are always reminded by the relevant regulatory institutions in our respective countries. Preparing for preventive measures allows institutions to adopt holistic and inclusive strategies for ensuring the continued functioning of the criminal justice system and equal access to fair, timely, and effective justice services. And young lawyers need to understand that protecting yourself is much more important in the midst of the pandemic, much as communicating the law and having access to the services provided by the judiciary and other law enforcement is equally important. But we are looking at the health, the health security of these young lawyers. So since criminal justice for lawyers involve critical issues related to visiting prisons and detention centers in answering the call of meeting their clients, it is important to reduce the risks in these prisons for people coming from outside, including ourselves, the lawyers, in order to consider ensuring access to justice for specific populations groups such as prisoners. That is, when you have clients in the criminal law perspective, definitely you'll expect to have prisoners or people in detention facilities. Not all lawyers practice criminal law, but on this particular subject, we are talking about criminal justice and the challenges being met currently in the middle of the pandemic. So access to legal aid will be efficient in if both lawyers and their clients are fully protected. So I wanted to emphasize on that, and there are a number of examples in different countries in East Africa and beyond. Criminal justice practitioners continue, but these protective measures are very, very important as one of the key advices. The second point is, I thought about this in view of the SDG 16, which calls for achieving more peaceful, just and inclusive societies. That's how I developed it, because rethinking and investing in new ways of making justice systems more responsive and inclusive to all. What does this mean? It means that the legal practice, for young lawyers, they need to understand that this practice requires promoting the public good in relation to justice and the provision of legal services. This pandemic calls for a renewed effort to globally look at the Sustainable Development Goals, particularly SDG 16, which calls for achieving more peaceful, just and inclusive society, the inclusion aspect for sustainable development. So young lawyers should therefore work along the lines of collaboration with the justice sector institutions, to police, judicial officers, legal aid providers such as lawyers, civil society organizations, all-inclusive, community paralegals of correctional services, and all this holistic, inclusive of a justice sector, so that they work along all those lines. Because the pandemic demands all this. The pandemic demands lawyers to be sharp, think ahead of time, and be able to think about inclusive society in view of achieving justice. So they need to work together to take on a people-centered approach to resolve the justice problems emanating from this global pandemic. So when you have on board the law enforcement agencies and the judiciary and all other actors, and working through the mirror and the cooperation of our respective bar associations, we definitely have to achieve our goal and objective as advocates, as practicing lawyers. The third point is a strategy of promoting institutional relations. Of course, I have mentioned it, working through their bar associations to address the challenges, but I need to emphasize on this because lawyers in different countries have got bar associations, have got law societies where they belong. So working through them to address the challenges of this nature is very important, along with the prosecution and the judiciary, because criminal justice is primarily the business of the prosecutors. Young lawyers, especially through their respective bar associations, have a critical role to play in ensuring the continuity of the criminal justice system despite the challenging pandemic. Giving the example of Rwanda, the Rwanda Bar Association, for example, has worked closely with the Ministry of Justice has worked closely with the Rwanda Correctional Services and law enforcement institutions to ensure continuity of prison visits for lawyers willing to meet their clients upon securing successful negative tests for COVID-19 pandemic and upon observing strict rules of social distancing. So this is happening in many countries. I know it is happening in your respective countries as well, and it is also taking place here. This kind of relationship has allowed continuity during difficult times of the pandemic in ensuring lawyer-client communication, as mentioned earlier, especially prison visits. So this strategy, therefore, should also consider that courts, when we look at the courts as the guarantors of justice, they do not act in isolation. They are part of an interconnected justice chain. And there need to be an inclusive process of consultation with all the key actors. So to develop a response plan, because we are assisting clients who have committed crimes, who are likely to be in detention, whose rights, the rights of the accused persons have to be respected in criminal proceedings, and so on and so forth. And these young lawyers coming in the legal practice have to understand this fundamental and important matter. So when you look at all these institutions have public relations offices that usually communicate with the public. So they need to reach out and to pursue the programs put in place by courts of law and to pursue programs put in place by the correctional services, as well as the prosecution offices and the investigation bureaus like CIDs in East Africa. In Rwanda, we have what we call Rwanda Investigation Bureau, which acts as a CID in East Africa. So you need to have access to the public relations of these institutions to be able to understand how to assist your clients. Very, very important. Because these institutions usually communicate to the public, so it is important for these young lawyers to access information in this regard and act according to guidelines provided by different institutions. Criminal justice is an intertwining and cross-cutting aspect of law. So it's an intertwining of agencies generally and processes which seek to achieve control of crime, minimization of crime, and the imposition of penalties for the commission of those crimes. So you are going to need a lawyer to explain all this to the clients. Some of the clients are ignorant and they don't even know about the law. Some of the clients are literate, some of the clients are educated. So you have all this kind of pool of which the young lawyer coming into this profession have to understand on how to manage the situation. So it is therefore associated with general fair trial guarantees, of which I advise young lawyers to pursue diligently in favor of their clients, e.g. fair trial guarantees such as independent and impartial tribunal that will have to hear the case, the right to public hearing to be tried within a reasonable time, etc. But we also have specific rights of defense, of which these young lawyers need to understand, such as presumption of innocence, information of the accusation, things like assistance of counsel of their own choice, adequate time and facilities, and so on and so forth. So this is one of the things that has been impacted by COVID. And this is one of the important things that young lawyers need to understand and address. So going to my fourth point, of course, with the challenges that we are currently facing due to COVID-19, we are practicing virtual courts and sessions remotely, online. So young lawyers should enable themselves to use technology in the current global pandemic, to adhere to physical distancing measures. While virtual legal proceedings have been around for quite some time, it now looks like the legal community has finally adopted them as a permanent fixture for the challenging pandemic to address criminal law. So court procedures in the midst of the pandemic understand this. And it is strongly advised that young lawyers adopt this measure as it is cost effective, first of all. Young lawyers with their skills should catch up very, very quickly with the requirements and adopt this measure, since it has advantages of which we are all aware of. That is potentially significant cost and time efficiencies that can be achieved by holding litigation proceedings virtually. Because if you're not going to court and you're seated in your office, having a Skype court hearing, it has saved some of your resources, and the trial is going to be conducted online. So it definitely such as high-speed internet, and it as in a criminal procedure be at the same pace of the quality successful online court sessions are conducted. Coming to my conclusion, it is my understanding that not all criminal law court procedures are at extreme risk. As long as adequate protection is put in place with regard to COVID-19, court proceedings should be conducted in person to safeguard the rights of all parties in criminal matters, as well as the publicity of hearings, which helps ensure the transparency of the proceedings. Yes, we accept that the pandemic is affecting criminal process. However, particular effort must be made to ensure that remote hearings do not interfere with due process and fair trial rights, because the suitability of remote hearings may need to be determined on a case-by-case basis. In my understanding, lawyers are critical in ensuring that the principle of legality, the rule of law, and fundamental human rights are it is therefore my firm advice that young lawyers should follow up existing rules of their profession in the middle of this pandemic, work closely and share their views within the justice sector to ensure rights of the accused clients are fully respected. So briefly, these are the key points that I would put forward to the young lawyers, and generally also concerns senior lawyers, because this is the situation that we are getting through. Thank you very much for your attention.
Thank you very much. Oh, yes. Mr. John Bosco, that was very insightful, especially from the perspective, the bar perspective. We want to thank all the panelists too for today. Before we do our Q&A, I will just do a small summary on what we've been taught today, the wisdom they've shared. Justice Makarama emphasized on the importance of knowing our judge. We should have in-depth knowledge of who they are. We have Justice Kiabure emphasized the need of collegiality, preparation, and the need for us not to be adjournment specialists. We've been called adjournment specialists. We should at least do a maximum of 2 adjournments. There was Justice Sekana Musa, who has emphasized the need for us to prepare draft pleadings that reflect on how adequately we have prepared, and not to be masters of doing a one-pager defense. That was a highlight for me. He reminded us of the ingredients of auto garage and motocop. That was a good one. Justice Mabea has said our submissions must be structured and there must be a flow. We must present our submissions in a logical and sequential manner. We can learn this by reading judgments. He also reminded us that judges are humans. Lastly, we had John Bosco Utangana, who has taught us about the need to remain professionals even during our virtual meetings. They need to remain with the same decorum that we've been taught earlier by the previous panelists, even during the virtual meetings. Thank you so much, our panelists. We have questions, very few questions. Okay, there are very many, but I think I'll just be summarized. So the first one will be going to, I don't know if he's still here. There's for Justice Makarama, one of the person has asked that some senior counsels never introduce junior counsel. as a junior counsel, what should I do in case I'm not introduced? I think you'll just note down and then we'll have an answer session quickly. Now, the other question goes to Justice Mabea, where someone asked if a counsel for the respondent in application and their time length given. Submissions, and I want to do submissions for rejoinder. What should I do to be the judicial officer's timelines? I think that is mostly on timelines. The other one is to Justice Mabea still. Your Lordship, how best can counsel who has caused a distressing phase to the judge rectify such a mistake? There's another question on this is to Mr. John Bosco. Sir, thanks for your presentation. My question is simple and goes, it's now like a law that whenever a suspect is in RIB for investigation, he or she must be detained before even concluding with the investigation. What is your take on that? I think we'll take those ones and then do a second round of the questions. We'll start with Justice Makarama, if you're with us, my lord.
Thank you. Can you hear me?
Yes, we can hear you, my lord.
Yeah, thanks. First of all, I must thank the other presenters for emphasizing on some of the points which I raised, and also for the questions which has been raised regarding my presentation. Now, if a senior counsel does not introduce a junior counsel, first of all, what we should know is that there is no law which mandates introduction. That's what we call court decorum and protocol. It should be observed. If a senior counsel does not observe, then the junior counsel naturally will proceed to introduce himself to the judge, because after all, the judge is not interested in a delay. So that is what you can do, but there is no offense. But what I'm saying is that there is not even a disciplinary action against not being introduced. But what I said is to maintain decorum. Most senior counsels know this practice, and actually they try as much as possible to introduce the junior counsel. But if you are not introduced, don't take offense. Just proceed to introduce yourself to the judge, and the judge will proceed as if nothing has happened.
Thank you so much. Justice Mabea, I think the other question was directed to you, the two questions.
Thank you, Mara. Thank you for those attendees who have asked the two questions. On the first question, where the timelines have not been adhered to by the advocate for the applicant, there are two things that I suggest you should do if you are counsel for the respondent. After the 14th day have already passed, if you are minded, you should proceed and prepare your submissions and file them. File and serve. If he files his submissions after yours, then do a rejoinder. Because at the next mentioned date, what might happen, there are two things might happen. If the judge had given timelines and said time was of the essence, his submissions will be struck out and will not be considered. Instead of you waiting until the last minute, he files after 27 days, and on the 28th, you don't know what to do. And then you cause an adjournment, or you make the judge, when you appear before the judge to confirm whether the submissions are on time, then it does not look well organized. This is what I call about impressions, that the judges are human. If you are always on time and the other one drags his feet, it's a plus for you, counsel, for being on time and following procedures. Using the overriding objective. In Kenya, we have what we call overriding objective of the act, the civil procedure. The judge is entitled to exclude those submissions of the applicant. On the second question, where the counsel has caused a distressing phase to the judge, the best way to do is once you realize you have done that, just apologize to the judge and all will be well. Thank you so much.
Justice Mapea, thank you for that. You can do your closing remark as we go to the next justice, please.
Thank you. It has been a pleasure to be here and to present my thoughts to the young lawyers. It is a passion I have. In Kenya, I usually go to the Kenya School of Law where they are being mentored to mentor them so that when they come to the field, they are doing a good job. And I believe that those who have attended today, whatever thoughts that you have gotten from these great minds will go a long way to make a difference in the profession, in your practice, in your practicing in your various jurisdictions. Thank you so much. Thank you so much for moderating.
Thank you. We'll have the next question to John Bosco as you do a closing remark too. Unmute.
Okay. Let me first respond to the question related to determining, arresting suspect before investigations are concluded. There's different criminal law procedures that determine on the arrest procedure. This is one of the key issues that young lawyers have to understand. First of all, from my own experience as a former prosecutor, I was a prosecutor for 20 years before I crossed to private practice. The relevant issue here is that any arrest is governed by criminal procedure. In some instances, depending on a particular crime, either felonies or whatever, they may be arrested even before investigations are completed, depending on jurisdictions. In Rwanda, we have what we call serious grounds to believe that a crime has been committed. That is enough for you to be arrested. Serious grounds to believe that a crime has been committed. And such serious grounds are listed in the law. In Uganda, there may be something, Kenya may be something, South Sudan, Tanzania, etc. But generally speaking, the principle is prosecutors and law enforcement should not arrest anyone before investigations have reached a certain level to constitute a prima facie case. That is my understanding. And lawyers should understand that they can always challenge that arrest before the pretrial judge on criminal procedure matters. So the arrest by law enforcement does not necessarily, cannot be necessarily be confirmed at the court level, because in this case, we are talking about courts of law. They are going to examine this arrest, whether it really conforms with the standards required of human rights in criminal proceedings. So my closing remark is that, first of all, I thank you so much for inviting Rwanda Bar and through me, of course. And I believe that our contribution will be taken seriously by the young lawyers, and they should feel free to contact us anytime they wish us to give some advice. And I thank all the justices, honorable justices who are presented, and the moderators in this forum. Thank you so much.
Thank you so much, John Bosco. That was a good insight from the bar. We'll get Honorable Justice Kirwabire for your closing remark.
Thank you very much. This has been a distinct pleasure participating in this mentoring session. I hope we can have more, but more importantly, I hope it will have impact on whoever has listened, and it will better your career so that we're all able to ensure that the practice grows and the ethics and profession at a very high standard. I thank you very much.
Thank you so much. That was very insightful. Will Justice Sekana, you've been thanked on the chat box. We'd like to hear your closing remark.
Thank you, Madam Moderator. Mora and others behind the scene. It was a pleasure definitely making a presentation to young lawyers, and it's always my pleasure to guide the young lawyers. I know men have appeared in my court, and I've always told them, I think you ought to do better. Sometimes after a case, I say, I want to talk to you. So I think maybe you did not prepare, or you ought to do things in a better way. And some of them take it in good faith. So maybe senior counsel just sent me, I wasn't prepared. So I think you ought to do better, because you want to see him improve, and we all went through that. several judges used to tell us that things were wrong and then you would improve. I believe that such different discussions are encouraged so that those who are interested really can improve. We've all learned through similar talks or similar advice from seniors as we've gone through our career up to where we are. I thank you very much. I thank the Honorable Justices who have been on the panel. It was a great pleasure being part of this. Thank you.
We are the ones who are really having a good time with this mentorship. Someone has stated that it's not hard to come by, but I think as young lawyers, we should approach seniors. They are ready to help. Last but not least, because the first will always be the last, we have Justice Makarama.
Thank you, Mariah and the team for the good arrangement and for having me on the talk. And also, I'm glad I met some of the justices I've never met before, and I enjoyed listening to their presentation. And for the young lawyers, I guess one thing which you should go home with is that you'll never become a good lawyer until you die. So keep on learning, and the practice will perfect your profession and never get discouraged. And for the judges, most of us are fairly accessible nowadays, so don't feel shy when you want to access a judge, but actually you should take into consideration his time. But most judges are very friendly. They are not animals, they are human beings, as we've been saying. And I thank you for having me, and I thank the other panelists for their talk, and I think we shall keep this fire burning so that our lawyers, young lawyers, will become better lawyers in the future. Thank you so much.
Thank you so much. I've learned something new. You said you never become a good lawyer until you die. I hope to become one though. My co-host, before I conclude, Rachel.
Thank you, Maura. I want to thank all the young lawyers that, of course, not everybody that came on is a young lawyer, but I want to thank all of them that came on. We've had almost 230 participants. Right now, they're reducing because they know we're closing, but we've had almost 230 participants. I'm grateful. Thank you to all the justices, everybody that came on to give us mentorship. We are grateful. And many are asking about the PowerPoint presentation. I think it's going to be made available. Yes, thank you so much and have a lovely evening.
Thank you, Rachel. We sincerely apologize for the absence of Justice Alala. The internet in South Sudan was really not available. He has promised to come one of the mentorship programs. Thank you, everyone, and have a good evening.